Common law doctrines result from legal decisions made by judges in cases adjudicated over centuries. Several doctrines, such as constructive discharge, can have severe and costly consequences for employers. Constructive discharge occurs when an employer makes the workplace so hostile and inhospitable that an employee resigns. Courts may find that a worker's resignation or retirement may not be voluntary because the employer has created an intolerable work environment or has applied other forms of pressure or coercion that force the employee to quit or resign. In many states, this gives the employee a cause of action against the employer. The required legal standard varies widely between the states, with some mandating an employee to show that the employer intended to force the resignation. In contrast, others require the employee only to show the conditions were sufficiently intolerable that a reasonable person would feel compelled to resign. It is usually hard to prove constructive discharge, and the burden of proof lies with the employee. They have to present specific facts that prove the employer created a hostile work environment that led to or would lead to their resignation. To win their constructive discharge case, an employee must prove three things. One, under the same circumstances as the employee, a reasonable person would have found the working environment hostile. Two, the employee brought the situation to the attention of the employer. And three, the employer failed to address the problem. If an organization wants to minimize the risk associated with constructive discharge claims, they must ensure that employee treatment is consistent across the organization and avoid even the appearance of retaliation.